Colorado lawmakers to consider prohibiting marijuana-related employment discrimination. Colorado made news in 2015 when the lawsuit involving Dish Network firing an employee for marijuana use was upheld by the Colorado Supreme Court. In 2012, Dish Network fired Brandon Coates, a paralyzed medical marijuana patient, for failing a drug test. He filed a lawsuit under Colorado Revised Statutes 2434402.5. The Colorado Supreme Court held the language of the statute prohibiting employers from terminating employees for engaging in lawful activity did not apply to conduct unlawful under federal law. Denver NORML is pushing for legislation to amend CRS 2434402.5 to protect employees from termination for off-premises marijuana use. Coates versus Dish Network. In Coates versus Dish Network, the Colorado Supreme Court considered whether CRS 2434402.5 protects activity lawful under state law but not federal law. This statute generally prohibits employers from firing or otherwise taking an adverse employment action against the employee on the basis of lawful activity during off-work hours. Under the statute, employees can still be terminated for lawful activity during work hours. Coates argued through his attorney that Colorado had legalized his medical marijuana, therefore his use was lawful. The Colorado Supreme Court took the opposite position, holding that the statute did not prevent employers from taking action against an employee for activity that was unlawful under federal law. Proposed legislation to change the outcome in future marijuana employment cases. Denver NORML proposes legislation that extends Colorado's Unfair Employment Practices Statute, CRS 2434402.5, to protect employees from adverse employment acts by the employer for using marijuana off-work hours or from testing positive for marijuana in a drug test. The proposed legislation will still allow employers to take action against an employee who uses marijuana at work or is under the influence of the drug at work. The advocacy organization will begin lobbying for the legislation this winter. The proposed statute is sure to find opposition from the business community in the state, who expect a high degree of servitude from their employees. This proposed statute is similar to a law already enacted in Maine for the same purpose. Contacting a Denver employment lawyer. If you believe your employer took adverse employment action against you on the basis of off-duty activity, then you should talk to a Denver employment lawyer right away. Employees in Colorado are generally protected from termination and other adverse employment acts on the basis of off-duty activities. Although for now partaking in marijuana is not protected by the Colorado Revised Statutes, it will likely only be a matter of time before Colorado employment law changes to align with the state's legalization. State or federal law may provide other claims related to your off-duty activities. Contact a Denver employment lawyer to discuss your situation.